My name is Will Soprano. I'm here with Kim Wilson here at her office in downtown Raleigh. Kim Wilson is the managing shareholder of Wilson Law PA. They're covering the downtown Raleigh and what other areas of North Carolina are you covering, Kim?
We handle cases statewide in North Carolina, and we also represent folks nationally in the areas of pharmaceutical and medical device litigation.
Awesome. So today this is our first podcast that we're doing. It's the first of the series, and we're going to get into some of the informational material that you've already put out, some stuff that you have coming forward. And before we get there, we're talking about access to the courtroom. What does access to the courtroom actually mean to us, the middle class America?
Quite simply, it means the ability of anyone who has been harmed by the negligence of another to go to court and have the opportunity to try their case to a jury of their peers. And of course, in North Carolina, access to the courtroom has been limited by tort reform.
Okay, so it's been limited, so that means that it's harder for an individual who's been hurt to get their case to a courtroom so that there can be a trial by their peers. Is that what I'm hearing?
That's exactly right. And something I've said throughout my career is the one thing that makes an individual equal to a corporation is in power is access to the courtroom, and quite frankly what that means is the ability to sue that corporation, whether it be a small business or a billion-dollar corporation, for an individual to sue that company or that healthcare provider or maybe just another very affluent person in the event that they have been injured by that person. And there's various ways, that happens. An individual can be hurt by a blockbuster pharmaceutical like Vioxx or Fen-Phen. They can be hurt by medical devices like hip implants or heart defibrillators. So it's very important that when individuals are injured, that they have the ability to seek redress in the courts. Of course, the judiciary is part of the American system, along with the legislative branch and the executive branch. And in North Carolina, tort reform has made it much more difficult, mainly for just kind of the middle-class America to even obtain a lawyer to take their case and get to the courtroom.
Okay, so what we're really talking about here are obstacles that are being put in front of us. And so we have the obstacles, and I'm kind of picturing this as an actual obstacle getting to a courtroom. But what happens, let's say in the event that we were to jump all over all of those obstacles, we got to the courtroom, what else is tort reform doing that is negative for, it's hurting the singular person who might have been hurt? What else?
Well, first of all, let's talk just very, very briefly about those obstacles. Some of the things that tort reform has done, for example, if you were a loved one, your child or your husband was injured in the ER by the negligence of a doctor, ER doctors are now given special immunity. It's much more difficult to sue an ER doctor as opposed to a family practice doctor. So that's one obstacle, for example. And then, of course, once you do get to the courtroom, there are other obstacles inside the courtroom. For example, the most egregious is caps on damages. So in North Carolina, you are limited to $500,000 of non-economic damages. Now that sounds like a lot, and that is a lot of money to all of us, no doubt about it. But when you have a child who perhaps has lost their limbs, or um, something other very egregious has happened, I could give you several examples, but $500,000 is not a lot to make up for two legs that perhaps has been lost because of an untimely diagnosis of an infection. Okay, $500,000 is not a lot of money when you had a abscess in your back that went weeks and weeks and weeks undiagnosed, and you went to the doctor every single day and was in the hospital trying to get a diagnosis, and suddenly you're 50 years old and can't walk. It's not a lot of money. So North Carolina now has caps on damages. The other thing North Carolina has in place now because of tort reform is this concept called bill versus paid. And what that means is an individual could have been injured by the negligence of another, whether it's in a car wreck or by a healthcare provider, or even by a pharmaceutical company. And let's say they have $150,000 in medical bills. They are no longer allowed to present that evidence as an amount of their damages. And that's really terrible. The logic is, well, chances are the insurance company paid for a lot of those medical bills, and the person didn't pay out of pocket. Well, of course, these insurance companies always have a lien on the case, so chances are if the person gets a verdict or a settlement, they're going to have to turn around and pay that insurance company back. And that's what the public doesn't realize. And what's really unfair is chances are the person that's being sued, the big corporation or the doctor, they have an insurance company that's going to pay for the verdict. You don't get to present that. So it's really, really unfair. And there's other things that have been under attack in terms of average people being able to hire a really good lawyer to pursue their claims. I hear lots of people talk about ambulance chasers and attorneys accepting payment by contingency fee. And that's a very important concept, because without lawyers willing to take a contingency fee, most people could not afford to hire an attorney, because attorneys cost several $100s an hour, and you're just very common working class individual can't afford to pay an attorney $500 an hour. So it's very important that there are lawyers out there who are willing to say, you only pay me if I get you a settlement or a verdict, because otherwise people could not afford to hire an attorney. So lawyers accepting a contingency fee, certainly from my standpoint, and the public should be aware that that's a very good thing, and we want to keep that fee arrangement in place.
So I'm hearing a lot of, what's going off in my head right now is money. I'm seeing dollar signs in my head. It seems to me like a lot of these obstacles, a lot of these things that are, I don't want to say oppressing, but that are really, making it difficult for the middle class, regular citizen, these obstacles are more financially motivated. So it's the money that's not allowing us to really get what we need. And you also mentioned contingency fee. You're a lawyer that works off contingency fee, right?
Yes, I do both, but mostly for personal injury cases, medical malpractice cases, pharmaceutical litigation. I work on a contingency fee because the folks I represent, they could not afford to pay $500 an hour, $300 an hour. Gosh, there's most of my folks, if they had to pay me $100 an hour, they couldn't to litigate their cases. And so what you got to understand is this gives them access to the courtroom that they would not otherwise have. Big corporations, doctors, lawyers, other folks, they can afford to pay hourly rates. But just, the average Joe out there, who certainly is my client, they can't do that. So I give them the opportunity, and I give them a way to hire a highly competent attorney who has experience, in the specific areas that they need, and they can pay me in an affordable way. So the contingency fee it's very important, and it's very disturbing when I hear that fee arrangement criticized. And talking about the financial burdens in tort reform proponents are big business and wealthy individuals. That's who wanted tort reform. That's who got tort reform. Tort reform does not help or assist everyday citizens hurt by the negligence of another. So all you have to do is look at who's proposing it, who's lobbying for it, to understand who it helps.
So, in looking back, this morning we were looking back at some of the content that, and some of the informational pieces that Wilson Law has been putting out for the public. I think it's really important because you find it, and you think you hold a high value to being informational for the public, for the average citizen. So you're doing your best to really put out some informational material. And so I wanted to get into some of the things that you've already put out in terms of topics, and maybe kind of going forward, what can we expect to see from Wilson Law on a content basis?
Yeah, the one thing that was very important to me when I launched this law firm 2 years ago was that my website was going to be a source of information. I mean, if that turned into me getting clients, great, but I wanted the public, whether or not you need an attorney or not, to be able to come to my website and get information. And so a lot of the blogs and information on my website, it is there really to inform the public. For example, we've done a big series on the Affordable Care Act. I'm not taking any position right now as to whether I love it or hate it. Honestly, too soon for me to tell. But what I wanted to do is let people know it's there and how they can access insurance or sign up for insurance now that we have Obamacare in place. So that was very important to me. The other thing is, because of the needs of my current client base, we now have a department here at Wilson Law that does estate planning and elder law. And we've put out a lot of blogs on important documents that every single individual in family needs, like the financial power of attorney or healthcare power of attorney, or how to go about getting a will or updating your will. This is just really basic information that the public needs to know, and quite honestly, I've come to find out that lawyers are the worst about not having these important documents. So that's been interesting to us. The other thing that I've done my best to write articles on is why an injured person, someone injured in a car wreck, for example, why they need to hire an attorney and why they should not talk to an insurance adjuster without an attorney. One of the first articles I put out was, rest assured that when you're in a car wreck, the other side's going to have an attorney. That insurance company calling you up trying to make you take $500 when you've sustained a broken arm, or you've been black and blue from a car wreck that was not your fault, rest assured that that adjuster is talking to an attorney, probably a whole department of attorneys. So why shouldn't you have an attorney? And I tried to impress that upon prospective clients, or just not even a prospective client, just someone injured in an accident. They don't have to come to me, but they need to go to someone. So we use this blog as an educational tool for the community. Coming forward, I'm going to talk about, and have talked about, we'll talk about it more, the FDA just issued a safety alert with regard to testosterone therapy. That really concerns me, as a lot of my clients know, and a lot of my colleagues, in addition to being a lawyer, I have my master's in public health, and throughout the years, most of my cases have some sort of medical slant to it. So I'm really big into public health, and one of the cases I'm currently looking at is how testosterone therapy has injured males who have used it. There's a lot of people out there using testosterone therapy, androgel, and those sorts of medicines, and they use it for erectile dysfunction. They use it to feel better. They use it to improve their mood. What we're finding out is testosterone therapy is being used off-label. Basically, a 35, 40-year-old guy goes to the doctor, doesn't feel good. It's like, hey, let's give you some androgel. Let's see how you feel. If that person has an underlying risk for a cardiovascular event, meaning high cholesterol, high blood pressure, a family risk of a heart attack, that person is at a substantially increased risk, according to some studies, to have an event. And there have already been deaths related to testosterone therapy, and there's been some serious injuries. So I've written a blog about that, and there will be more blogs to come, and these are cases that we're investigating. But back to your point, my blogs will be a source of information and awareness for the public, and if anyone out there has ideas or topics they would like me to investigate and write about, I would love to. I'd like to know what the public wants to hear, especially from a lawyer in my practice area.
Excellent. So if any, for those of you listening, go ahead and drop a comment down below, and let us know what you'd like to hear about. Kim is taking suggestions. So thank you so much, Kim. I'm leaving this with so much more information than I would have had, and we've only had a few minutes to discuss, but we've gone over tort reform and medical malpractice, the financial burden and the financial obstacles that are really hurting the average citizen in terms of getting access to the courtroom with tort reform. We talked about contingency fees and how those are helping a little bit for some of these financial issues. And we got into some of the informational materials that you're putting out. And we're excited, I know I am, to see going forward what comes out. You mentioned low testosterone, and you are taking low testosterone cases now, right?
Yes, we are. We just started investigating those claims, and that's going to be an ongoing process. So if there's someone out there who just wants to discuss this with me, feel free to give me a call. I work very unconventional hours, and if you're just looking for information, call my office.
Great. Well, thank you so much, Kim. We are going to go ahead and wrap this up, and for those of you listening, we will have more podcasts going forward.
Thanks.